Be ready. 5 seconds. Sir, the amendment on the face of it is small, but the implication of this amendment is large. Basically, the government had taken cognizance to redress the grievances of all those people in whose case the judgment was given after 2008 in the state of Nagaland and after 2019 in the state of Himachal Pradesh. So, the government has taken cognizance of this fact, and I rise here to support this amendment. Sir, basically, the amendment is to validate all the orders with retrospective effect. The Parliament is competent to enact such type of laws with retrospective effect to validate all the orders or judgments given by those courts which were established in 2008 in the state of Nagaland and in 2019 in the state of Himachal Pradesh. I fully support this amendment. I would also like to say that this amendment is basically for the establishment of courts by way of notification within the domain of the Government of India. Now, the Government of India is bringing this amendment under Section 13 because the courts are required to be established at the relevant time. Since it was not done at that time, therefore it is being done now. Now, the proviso has been added under Section 1, subsection 3 of this bill, whereby the court has been deemed to be established with effect from the date when the respective state government established the family courts in their states. So, this legislation has been brought in with respect to the state of Nagaland and with respect to the state of Himachal Pradesh with effect from 2008 and 2019 respectively. It is because during this period thousands of orders and judgments were passed. All these orders shall be deemed to be validated. This suffices validation under Section 3A without any validation or further order or without further amendment, with effect from the date when the courts were established in respective states. All the judgments shall be deemed to be validly passed by the competent court having the jurisdiction to pass the same. As far as Section 3A is concerned, for validation of certain actions, Sections 3A 1, 2, 3 and 4 were added. Now, I would like to seek clarification from the Honorable Minister regarding Section 3A, which talks about validation of certain actions. In Section 3A3, it is mentioned, every order of appointment of a person as a judge of a family court and every order of posting, promotion or transfer, as the case may be, made under this Act in the states of Himachal Pradesh and Nagaland prior to the commencement of the Family Courts Amendment Act 2022 shall be deemed to be validly made under the provisions of this Act. Here I have some doubts whether this provision will stand judicial scrutiny or not. Suppose some cases might be pending with respect to the promotion or transfer of a particular individual, and if that particular court of competent jurisdiction quashes that promotion, then there will be an analogous situation. So, in my view, this provision is superfluous and it creates confusion. I do not think that this provision is needed if the purpose is served by providing establishment of a family court under Section 1(3), then this set of provisions is not required. Apart from this, I would also like to make it clear that for appointment of the judges of High Court or Supreme Court, there is no doubt the involvement of the Government of India and also the involvement of the respective High Courts and the Supreme Court. But for the appointment in subordinate judiciary, it is the involvement of the respective state governments and the respective high courts. A large number of vacancies are available. On account of the availability of vacancies, arrears of cases are there. In family courts also, the parties are suffering hardships. For 30 years, the cases in the family courts remain pending. So, this situation is prevailing not only in one state but also in other states. There is no doubt that the Government of India has issued advisories to the respective state governments and the high courts from time to time for making the appointments and filling up all the posts of the subordinate judiciary in their states. It is because in family courts the officers from the subordinate judiciary can only be appointed. So, once the vacancies are filled up, the agony which the families are facing and the issue of justice not being imparted on time can be redressed to a greater extent. Sir, Nishikant ji had raised the issue regarding NJAC. So, I would like to add that Article 366 of the Constitution of India, which is basically a definition clause, defines various words used in the Constitution of India, but at the time of framing the Constitution of India, the word consultation was also used.